Mr. Jude.
Well, I disagree with that statement. And even Elena Kagan, I believe, had written contrary to that prior, a few years before, saying that the whole confirmation procedure in the U.S. Senate had been reduced to a theater. And it's a theater of how little the nominee is required to disclose. And unfortunately, it's been that way since President Reagan had nominated Robert Bork to the Supreme Court back in the 1980s. And Robert Bork, I thought, was a very forthright, honest nominee. And unfortunately, as a result of that, he got skewered by then Senator Biden and his committee in the U.S. Senate. And that was extremely disappointing. And ever since then, every nomination that's come before the U.S. Senate has been a theater on how little can be said about their approach to the Constitution. Now, I think that would be very valuable to the public. I think we need to have that, and that's why this forum tonight, I think, is very valuable for the voters.
Thank you. Ms. Arnold.
Thank you. I disagree with Ms. Kagan. Obviously, our political views and our constitutional views make us who we are. I think it's a very disingenuous thing to sit there and say, one day I'm a conservative, I'm going to run for election now, and so I'm not going to tell you who I am or what I think about or anything like that. So I do think that the information, getting the information out, saying who you are, any other way would be a disingenuous person. So I disagree with Ms. Kagan. They are important as to the matter. And I will say as well, regardless of your political views and your constitutional views, in this realm, when we're running for district court judge, you still have to apply the law as written. Your biases, you have to recognize your biases, and you have to be able to go forward and make an unbiased decision as best you can. Thank you.
Thank you. The next question will be addressed to Ms. Brosnahan, Mr. Hansen, and Mr. Penwell. And this question is, in her confirmation hearings, Supreme Court Justice Sonia Sotomayor said, personal experiences affect the facts that judges choose to see. Do you agree? Ms. Brosnahan.
To a certain extent, I can see Justice Sotomayor's point of view. Obviously, an individual's personal experiences affect who they are as a person. For example, at the time, 7 men on the United States Supreme Court who were addressing issues related to the search of a teenage school child in the state of Texas had no idea what it was like to be a teenage girl. So to that extent, your personal experiences obviously would affect the facts that you see in a case. But one still has to, as a jurist, particularly at the district court level, try to, if there's biases in those personal experiences, set those aside and view them from the perspective of an objective observer rather than from your biased perspective of your personal experiences.
Thank you. Mr. Hansen.
Could you repeat it again so I have it exactly?
In her confirmation hearings last year, Supreme Court Justice Sonia Sotomayor said, personal experiences affect the facts that judges choose to see. Do you agree?
I'm going to parse it out a little bit. Personal experiences don't affect the facts themselves. It affects how they choose to see them, not the facts that they see, but how they choose to see them. And that's true for anything in life, whether you're, where you decide to, or where or what you decide to do of anything. Your personal experiences in your past affect your decisions on a daily basis. What makes a good judge or jurist is the ability to remove yourself from those decisions in a logical and reasoned way when hearing a case before you, to be able to put your blinders on, so to speak, and to be objective at the case before you.
Thank you. Mr. Penwell.
Thank you. I'm not sure I have a whole lot to add to that. It's similar to the last question in that we are the sum of our experiences. It's impossible that we just put aside our values, our beliefs, and our personal experiences. We necessarily bring those into everything that we do, and the courtroom is no exception. I think, as has been said, the key is to be conscientious about recognizing that and trying to step outside of that and try to be objective and make sure that the facts, whether the judge makes the decision or whether the jury is making the decision, there are rules of evidence, there are rules of procedure, they're time-tested. The judge needs to know those, and those assist in making sure that either the judge gets the right facts or, very importantly, that the jury gets the right facts. And so the judge just has to be very conscious of what his job is and to do that job the best he can without bringing those personal experiences into it.
Thank you. The next question will be addressed to Mr. Marker, Ms. McEnroe, and Ms. Burchell. And this question, at his confirmation hearings, Chief Justice John Roberts said, "Justices are like umpires. They don't make the rules, they apply them." Do you agree? Mr. Marker.
I do largely agree with that. I think that's especially true. I think it's interesting that Justice Roberts said that, because I think it's less true at the Supreme Court than it is at a district court. I mean, because they are creating precedent at the Supreme Court. But at district court, it is akin to an umpire, because you have rules that you're applying to every case, whether it's statutory law or case precedent. I think that's true. On the other hand, I think that also we're not computers up here. We're all people, and we all have a life experience that make us who we are. So I think to some degree the umpire analogy fails, but I understand what he's saying there. But I think it's probably less true in his position than it is in ours.
Thank you. Ms. McEnroe.
I also agree with the statement. Judge Rosenbaum, who I used to clerk for, used to say that a big part of his job was to call the balls and strikes with regard to the evidence. And I believe the analogy is also appropriate because a district court judge is the person in the trenches. The caseload is huge. The cases are moving quickly. The judge needs to make those decisions quickly, just like an umpire would not have a chance to replay the pitcher's throw to see if it was a strike or a ball. So I do believe that district court judges, again, are like umpires, much more so than U.S. Supreme Court justice.
Thank you. The next question will be addressed to Ms. Hennessy and Ms. McPherson. Did I miss anybody else? Good. Okay.
I think I have the umpire question. I should have dyed my hair purple.
I'm so sorry. Please.
Thank you. Well, I certainly know that sometimes I feel like I strike out with judges, so certainly they seem like umpires to me. At the district court level, it really is the place where the facts come out. And it's almost like it's a funnel where there's so much fact at that level. And it's very frustrating as a lawyer when there are certain facts of your case that you either have difficulty presenting because certain witnesses are unavailable or because of certain rules. So clearly it is a judge must take all those facts with a good understanding of the statutes, the laws, including case law, and then figure out how best to apply them, but also in a manner that is fair and provides justice. And really, what it comes down to is seeking truth. In the end, I think that's what you're supposed to do in a court of law, is figure out what is the truth here.
Thank you very much, and I'm so sorry. Okay, the last question then, Ms. Hennessy and Ms. McPherson, and this is a quote from Supreme Court Justice Earl Warren. He said, "It is the spirit and not the form of law that keeps justice alive." Please comment on this.